Let's go to this story now, and SAA's business rescue practitioners are going to have to wait a little while longer to find out if they can actually go ahead with retrenchments. As you know, they are appealing a judgment which told them that they couldn't go ahead with that process. Heidi Jokos is following the story for us. She joins us now live as well. So Heidi, just take us through what's happened so far and how we got to this point, the backstory first, of course.
Yes, indeed, Shahan. So the battle continues. The unions, specifically NUMSA, SAA and the South African Airlines Pilots Association, are saying that the SAA business rescue practitioners cannot implement retrenchments without an adopted and published business rescue plan. They took that application to court in May. The Labour Court agreed with the union, saying that in order for the business rescue practitioners to implement this plan, there needs to be an adopted business rescue plan. Without that, the retrenchments cannot go forward. The business rescue practitioners, however, have appealed that decision, and they are saying that they urgently need to implement and go forward with job cuts and retrenchments at the airline, because they say the plan is already on the table, but it just hasn't been adopted or published. So the battle continues between the union saying you are violating the Labour Relations Act, but the business rescue practitioners are saying we need to move forward. We're running out of money. We worry that the airline's going to be liquidated.
So why are the business rescue practitioners so adamant to go ahead with this process despite that?
Exactly. So we're hearing from unions saying that you're violating the Labour Relations Act, but the business rescue practitioners are saying that the current money and financial status of SAA is only going to push them through until the end of July. When that money runs out, the business rescue practitioners are worried that the airline is going to be liquidated. There was a creditors meeting that took place last week. That creditors meeting was supposed to have creditors and all affected parties vote on the business rescue plan that's being submitted. That was halted, and the business rescue practitioners are saying we're running out of money. We don't have 60 days to consult and discuss retrenchments. The business rescue practitioners also saying that when the airline went into business rescue in January, and when they cut flights in Feb, significantly cut most of their routes, they're saying that that was already an indication that they were going to cut jobs. But the judges that were hearing this matter today are not buying it. They are saying that the business rescue practitioners have been faffing. They used the word faffing for the last 6 months, and how could they not submit a business rescue plan? Let's listen to what one of the judges had to say.
Even if the plan is accepted by the creditors, there would then have to be a period of 60 days from the moment that the plan is accepted, because of the fact that there'll be reduction in the staff complement. Another 60 days will take place.
And of course, we have unions who are saying that's absolute rubbish and they're not allowed to go ahead with retrenchments now.
Yes, exactly. And actually, the legal team representing the three unions said, what is so difficult about submitting a piece of paper? They actually said it's just a piece of paper, and it's taken them 6 months to submit. But they're also trying to protect workers. They are saying that workers need to be consulted. They need to be part of a consultation process. And the fact that they are not being part of this process, it's violating the Labour Relations Act. They are saying that it's not the workers' fault that a business rescue plan has not been submitted on time. They are saying that it's imperative for the business rescue practitioners to do their job properly, and they have not done so. So they are basically saying that it's unacceptable, and judgment has been reserved. So we do know that the judges will go back, assess the situation, and decide whether or not the unions are right, saying that a business rescue plan must be submitted, or the business rescue practitioners saying we're in a very dire situation. If we don't retrench, we're going to be liquidated.
In the greater scheme, this calamity that Mr. Redding is talking about is in fact not going to happen if the business rescue practitioners, and this is why it's crucial actually that this case is before this court, because the message needs to go out that if the business rescue practitioners violate their terms of appointment because they are constantly asking for extensions, of course they will be told that you cannot retrench in a haphazard fashion because it's not contained in the plan. The reason the legislation puts a 25-day cap is so that you do this as quickly as possible after your appointment. It doesn't envisage that you will sit 6 months after the event and you have not produced. This is a piece of paper, Justice Davis. It is a piece of paper. How long does it take to produce a piece of paper?
All right, we're going to leave it right there. Heidi Jacques, from my home to yours. Thanks for that.
Thank you, Shahan. I want you to imagine lots of cheerleaders around here. We're very happy to have you back on air, and we hope that you're keeping safe and healthy.